we're going to cover, will it apply to your organization, how we should communicate those to our employees, how we can track the vaccination status under ADA and EOC guidelines. Then we'll talk about dealing with accommodations in the workplace. We'll talk about some COVID-19 testing, and then we'll get into that government affairs. So what's probably on most people's minds is, does it apply to our organization? And looking at the amount of different employers that we have on the call, I would say a good portion of you would be impacted by these mandates. So announced on September 9th, the White House Biden administration announced his Path Out of the Pandemic plan. So that required, under his pandemic plan, it's requiring all employers, 100 or more employees, to ensure their workers are vaccinated or tested weekly. Biden's team indicated that the Department of Labor's Occupational Safety and Health Administration, known as OSHA, is developing that rule and will require those employees with those 100 or more to be fully vaccinated, or require those who remain unvaccinated to produce a negative test at least on a weekly basis. So OSHA has already completed their portion. That mandate and information could be coming out any day. Additionally, they also have mentioned and talked about requiring employers to pay paid time off to get vaccinated. And there's also been some movement for additional sick pay in general. So we're going to break apart these things in an individual basis. The first mandate, which would factor in kind of most employers, would be those employers that hit 100 or more. So the recent one was on October 12th. The agency sent their emergency standard ETS to the White House for final review. That was completed Monday. So we are still waiting for that formal guidance to be issued at this time. Sometimes these things can take months, but Biden's administration has expedited the process for the emergency standard. So we are waiting for that to drop. It could drop any second. It could drop during this call, after the call, or in the coming days. In more detail, what we do know from the September 9th executive order, that vaccinations for all federal workers and contractors and subcontractors that do business with the federal government has been put into place. Here's a really good website. This gives the FAQ, and it's updated daily. So many of the folks that we deal with are government contractors or subcontractors. So this could affect many employers. The guidance for that was issued just recently on September 24th. The guidance requires federal contractors and subcontractors, again, to ensure employees working on or in connection with contractors are vaccinated by December 8th of 2021. So the task force has continued to update those FAQs, which I've provided that link on the slides. Since releasing its initial guidance, they have been continuously updating that. And so they do have a feature that shows you what portions are new. The guidance defines covered contractor workplace location as locations where covered contractor employees work, including a covered federal workplace, subcontractor, contractor, anyone essentially working on federal government contracts that has a covered location, and it also includes outdoor locations as well. So that would be, maybe your construction crew that are outside, that are not indoors. While employees' personal residences are not included in the definition of a covered contractor workplace location, employees working from home of a federal contract must meet the order and guidance vaccination requirements. So your remote workers are included in this ordinance. So if you are a government contractor, you've already been seeing those notices already come at you. Subcontractors, I'm assuming we'll start to see that trickle down a little bit later. Problem with that being is that the compliance is coming up. When we talk about contractors and subcontractors, since we have so many employers that fall into that category, that could include anyone for services. So it doesn't in this current guidance that we see, it doesn't cover products. However, it's encouraging agencies to expand its reach to cover products context too, to be accepting that in encouragement. So again, you've probably already seen some of those. For example, on September 30th, GSA issued its new clause, which will be inserted into all services and products. So do I sell government contractor, private contractor? Most contracts agreements are covered. Procurement and not procurement agreements are covered. Grants at this time are not covered. So it's a pretty in-depth. So when we talk about time frame, vaccination countdown to December 8th compliance. If they had the Moderna vaccine, they had to be vaccinated by October 27th. Pfizer, November 3rd, and November 21st would be the last day to receive Johnson & Johnson vaccine. Covered contractor employees. So going further, if you are a government contractor, if you fall into this or subcontractor, then you have to look at your employees too. Covered contractor include any full or part-time working or in connection with a covered contract. So they do define this even further. Working on or in connection with covered contracts include both employees working directly on contracts and employees who perform duties necessary to the performance of this covered contract. So they actually specifically cite human resources, billing, payroll, and legal review all would have to be in compliance. What probably is on a lot of people's mind, though, what about exceptions to that vaccine requirement? So they do note in all their guidance is that one of the exceptions may required for a covered contractor is to provide accommodations for those with disabilities or religious accommodations to those covered contractor employees. There isn't currently for federal contractors and subcontractors, there is not an opt-out provision for covered employees to submit weekly testing. And so when we looked at that initial path out of the plan, we were really expecting this guidance to include weekly testing, which we knew that would potentially be a burden on a lot of employers, especially if you had, let's say, half your population not vaccinated. There is another exception, though, is that if the contract is an urgent mission critical need, and so that's going to be telling those limited exceptions on that vaccine requirement. The guidance doesn't provide that full direction. It doesn't tell you how to evaluate religious or medical exemptions. We know, though, through Title VII and the Americans with Disabilities Act, that there's a lot of guidance that is already out there to help you evaluate whether or not you can accommodate religious or ADA disability accommodations. It is on a case-by-case basis. You will have to take a look at your organization, and we'll get a little bit more involved into that. But there are a lot of scenarios that can play into it, and I believe that's probably why they did not go into detail. But it is important because they don't note what that means. So yes, we know that we have to accept accommodations, but does that mean they can't come on site to those federal contractors? Again, they don't allow for testing, so we don't know how that would relate. So that may still be an undue hardship for some employers if those federal locations are still requiring that vaccine, because you would have to reach out to that agency head to see how they're handling their own accommodations. Federal contractors must ensure the employees are fully vaccinated within the 60 days of beginning to work on a contract or at a covered workplace. So covered contractor employees must provide one of the following types of documentation to establish that. Vaccination status would be an immunization record from a health care provider, a copy of the vaccination record card, a copy of medical records documenting the vaccination, or records of all types of immunizations from a public health or state program. A copy of any other official documentation bearing vaccination status is noted to be approved on that. They do note that photos of vaccination cards or a letter from the employee noting that they are vaccinated is insufficient. So they do need to show that documentation. When we talk about these FAQs that were updated. I just really want to really pull this FAQ. This is just copy and directly pasted from the website that was given earlier. Should agency provide employees who are seeking a legally required exception to the vaccination requirement with a form? So it does indicate, yes, agencies can refer a following template to develop a form for employees. So what we can infer by that is that it's extremely important that we have a way to account for accommodations in the workplace. So we'll go look in that in more detail a little bit later. Additionally, what also affected more employers is COVID-19 vaccinations for healthcare workers at Medicare and Medicaid participating hospitals and other healthcare settings. The Center for Medicaid and Medicare is still developing those emergency regulations, detailing that scope. They did note, though, that that was supposed to be released in October. We know that October has since been passed at this point, but we could expect it to come any day. It did also note, similar to federal contractors, there is no opt-out or ability to test. So we can only kind of guess what we're going to accept or what we're going to see. The Center for Medicare to Medicare is still developing that, but we know, again, that it's not going to include voluntary weekly testing or other alternatives mandatory to the vaccination. We also know that they are going to make account just the way that they did for federal contractors and subcontractors. They are going to require employers to make reasonable accommodations for medical and religious reasons in compliance with law. They're also going to allow us a time to be in compliance. So that's important. Is, how long originally when September 9th hit and released this guidance, we heard a time frame of 90 days if we're looking at what we have already released. So the only, out of all the topics that we talked about, federal contractors and contractors are the only ones fully in play of vaccination requirements. And so again, that's that December 9th timeline. The OSHA requirement we know is going to drop any day, so we're still expecting to see what happens there. Same with the healthcare mandate for Medicare. We're still trying to figure out what could happen, but we do know, based upon what was told to us, that there will be allowed some time for compliance. Additionally, we have also added was employers to provide paid time off to get vaccinated. PA has issued their own paid leave provisions for federal contractors and subcontractors. A lot of some of the stuff was brought out by the Biden administration, but we also have local governments getting involved. Governor Tom Wolf's administration told more than 70,000 state employees on Monday that they want to offer 5 days of paid leave for those getting fully vaccinated against COVID-19 by the end of the year. The Obama administration had also in play back in 2015, had indicated federal contractors and subcontractors provide certain sick pay based upon what kind of contracts they had. But these provisions could affect a lot of employers as well. So we know that that is a portion of the administration, is to provide those paid leave provisions. So at this time, it's going to be based upon where you're at. Certain states have allowed it, certain cities and counties. Remember, so as far as Pennsylvania, I know that's a majority of our base that we have today in terms of members. Look to ensure that you don't have any local mandates, and look to see if you fall in with any of the government contractor mandates when it comes to sick pay. So if we're looking at this, that's us. Where do we start from here? How do we go? We really need to, first start is, we need to go out and start surveying our employees. So how do we do that? We need to be proactive. We also will send you guys some follow-up documentation that you can have, but we suggest a sample survey for large employers. So if you have a lot, you really need to gather that data to anticipate the impact of that mandate. Some employees will most likely choose to leave the company rather than being vaccinated, and some may go ahead and get vaccinated. So you need to get that Head Start communications out. so that we're not left with potential worker shortages. We also need to, again, know the percentage of unvaccinated workers and their sentiments. And so if you survey those employees, you're going to have a better understanding of where you're at in your organization. Once we get that survey, and if you're already a government contractor that's included in this mandate, we're already past the time. So we really just need to start coming out by crafting our notice to those employees at this time. So we need to outline your requirements on current or upcoming mandate. So again, depends on when your fallout. If you're here because you're part of the Medicare portion, right, we don't know, but you're going to want to be in that survey phase. If you're in that federal government contractor stage, you're going to want to be taking this next step right away. You may need to send out multiple notices. Note your deadlines for compliance at the time of notice, and think about how you're going to send that out. But you're also going to need to be prepared for accommodations and documented that interactive process. I know a lot of you, we have a very big group here, but I know a lot of you may be on the roundtables. We have the EOC Speak, so it's a great program that the MBA offers for those who want to keep updated with kind of changing litigation. We've seen a ton of change over the past couple years. With every new administration, it tends to happen, so you get a lot of updates and changes. So things like handbook reviews, those are all really important things that each company should be looking for. And one that might be difficult or that you might not had a lot of experience in is those accommodations and that interactive process. The EOC just a few weeks ago told us, as far as the accommodation process for this mandate, it's going to be similar to the flu shot. So they basically directed us to look at previous litigation for flu shots. And that's going to be, based on that. And so this is the time, if, Jezre, if you're on, if you want to add anything into there, but you'll have to have possible forms available. And again, if we go back to those FAQs, they're going to want us as employers to provide some of those documentation for our employees for those circumstances. The biggest thing that we hear from the EOC is that the people that refuse to go through the interactive process is where most litigation happens. So I just want to point this out. Listen, depending on where you fall on the spectrum, whether you're, pro the mandate or against it, one thing that remains is that you have to still do the interactive process. So what I always tell my managers, I always tell my clients, listen, you might get to the point where it's going to be an undue hardship, or you might get to the point where it's going to be able to be, you're going to be able to approve that accommodation. On both ends, you still have to document that interactive process. So all those circumstances will have to be treated based on those facts. We know if we look at the federal contractor, because that is the only mandate that we have that's active, they mention all throughout all their compliance documents accommodations. They do note that it is unlimited circumstances. So that tells us a few good things that we know. One, we have to start putting those communication pieces out, saying that it's required, and then giving them that form. So that brings us to this next slide here. Just a sample. You want to include some verbiage on what's happening. So you want to say, hey, on September 9th, President Biden announced a plan directing OSHA or federal contractors, right, depending on what situation applies to you. In order to comply with this standard, company name is issuing an updated COVID-19 vaccination policy, and here's the requirement. So our requirement that all employees be fully vaccinated, the ability if they can have paid time off for vaccination related absences. So again, that's going to depend on where you're located, what jurisdiction you fall on, or company specific documentation. And then the option for weekly testing, again, optional based on type of leave mandate. We know that so far we've been told that is only going to be built into OSHA's requirements for the 100 over employers. So we know that for right now, we don't see that it's coming for Medicare, and we don't see that it's coming for federal contractors. We also have to note the consequences of failing to comply with the employer's policy. And then possibly what you could add is information on where they can get vaccinated. One of the things we want to go on more in detail about is we might want to add in obligations under the mandate that include penalties for noncompliance from the employer standpoint, right? I would say that most employers hadn't thought about mandates And some employers have thought about mandates before. Whether we agree with the policy or not, one of the things that we would have to let our employers know is hey, listen, we're required to do this. There's penalties, there's stiff penalties for non-compliance. So it's really, again, important to just let those employers know where you're coming from. Hey, we're doing this because we're required to, and here's those penalties if we don't. We also should note if those who don't comply could be subject to termination, and then indicate a person that they will need to send proof of vaccination status to. That person should be trained in some HR aspects, and we'll talk about how we can track this legally, but it's really important for that person that is maintaining that information to do so under EOC guidelines, as well as follow confidentiality requirements. Also, again, a note too, if it's a different person, would do the interaction process as far as accommodation. So again, as we note from the FAQs and the information that's been released already, in that letter you send to your employees, you should note accommodation requests should be made too, and then it's optional on your end if you want to provide that form to those employees on how to request, whether it is a Title VII religious accommodation, or if it is a disability-related accommodation. How can we track this legally? We could have probably a whole hour alone just on EOC guidance, but EOC guidance is going to help guide your interactions with both applicants and current employees. So if you know that your position is under a mandate, it's really important that you review this EOC guidance, because a lot of the questions that we're getting on the hotlines is, when can we ask vaccination status? We need to figure out who is impacted by that mandate. Do we need to send out all employees or just a portion? Remember, if you look at that federal contractor mandate, it's going to include anyone who has a hand over that, which could include HR. And we want to train managers on these guidelines. So managers should be fully aware of how to recognize an accommodation, as well as making sure that they know the guidelines and requirements too. So we'll want to assign staff members and that are able to handle that information. Again, remember privacy and confidentiality, so we can comply with those requirements. We also start having to review retention requirements on that information gathered. If it's a business required, remember OSHA has their own retention, so we may have to keep these types of documentation for a long time. It's really important to notice and really especially note privacy and confidentiality. We've heard of a lot of different employers asking, in interview stage. We've heard a lot willingly, openly talk about their own vaccination. Remember, we have to keep that confidentiality there. So if we know vaccination status to the degree and extent possible, we would need to keep that private. And also, we need to keep up an eye for changing requirements and or litigation that's coming up. We have to keep track and somehow note anyone missing information to ensure compliance. And really what's in short, and based on all the release guidance that we have, we know one thing is we have to have on file, if you're included in this mandate, a copy of a vaccination record, proof of vaccination, and or an accommodation exemption form on file. So in order to be in compliance for all those employees, you would have to have, again, one or the other on file. Now, again, it doesn't really help us to know if that means that they're not going to be able to go on site to these other places, but you'll have to, as an internal team, decide whether or not that you can accommodate those accommodations for religious reasons or medical reasons. The EOC provides a lot of guidance on this topic. They have a link right there, what you should know about COVID-19 and the ADA. So it does enforce anti-discrimination laws, including provisions under ADA and Title VII. So a lot of the topics I mentioned before, why it's really important, because we know it's happening a lot and we want to make sure that you're protected as the employer. And so we have the ADA limits employers' ability to make disability-related inquiries or require medical examinations at 3 stages. So they have it broken up. At first stage, prior to an offer of employment, an employer may not ask disability-related questions or require any medical examinations, even if they are job-related. On the second stage, after an applicant is given a conditional job offer, but before he or she starts work, then an employer may ask disability-related questions and conduct medical examinations, regardless of whether they're job-related, as long as it does so for all employees entering that same job category. Then at third stage, after employment begins, an employer may make disability-related inquiries and require medical examinations only if they are job-related and consistent with business necessity. Going further, job-related and consistent with business necessity. If a qualification standard or test screens criteria operates to screen out an individual with a disability, such individuals on the basis of the disability, then there has to be a legitimate business measure of qualification. It's not enough that it measures qualification for a general class of jobs. So the ADA itself does not require that the qualification standard or the selection criteria apply to only essential functions of a job, but it may evaluate and measure all functions as a whole in order to continue to select people who can perform all these functions. But it only, when an individual's disability prevents or impedes performance of a marginal job function, the ADA then requires you to go in and evaluate the accommodation and whether or not you can accommodate and have them meet the essential functions. When we talk about business necessity, it's if a test or other selection criteria excludes an individual based on a disability, based on the essential function of the job, and if it is not consistent with business necessity, a standard may be job related, but not necessarily justified by business necessity. So, that's a handful. ADA requires that if the qualification standard or selection criteria is job related and consistent with business necessity, then it may not be used to exclude an individual with a disability if they could satisfy the legitimate standard or selection with a reasonable accommodation. So when it comes to job related consistent with business necessity, before these mandates were coming out, employers were thinking, hey, can I force the mandate? And the one thing, we always went back to them. The answer is maybe, yes, and maybe not. Is it job related and consistent with business necessity? So if we look a very generic example, somebody who's going inside working with nursing homes and at-risk populations could be very justifiable to have a mandate for a vaccine. Somebody that is, let's say, a buyer that works remotely, that doesn't have any contact with at-risk populations, it may be difficult for you to prove that there should be a mandate or a job related and consistent with business necessity to get vaccinated. So it's similar to the accommodation phase. So when we talk about those mandates, right? Okay, if I have somebody who's going on site into those federal hospitals, it's required to be vaccinated or tested or just vaccinated, again, depending on where you're going to fall out, if it's under OSHA or the contractor method, then you're going to, again, have to go through that interactive process. So you may have employees in the same field that you might be able to approve an accommodation for, and some that you might not be able to, depending on the circumstances. So let's say you have two technicians, you have the bandwidth because half your business separates from federal into non-federal locations, then you may be able to accommodate one, but maybe not both. And then you would have to do it on a first come first basis as well. So again, there's too many variables to really give you a solid decision or kind of a guidance. But what we can say is you have to have an interactive process. We need to make sure that under law that we're following those obligations to make sure we relook at whether it's job related and consistent with business necessity and what those requirements are. Furthermore, I really wanted to pull out some EOC FAQs so that you can have it. Remember, under the ADA, Title VII, other federal employment non-discrimination laws, may an employer require all employees physically entering the workplace to be vaccinated against COVID, right? This was recently updated on 10/13/21, so this is their FAQs on the EOC website. It notes the federal EO laws do not prevent an employer from requiring all employees physically entering the workplace to be fully vaccinated against COVID-19 but they are subject to reasonable accommodation provisions of Title VII and ADA and other EOC considerations. So again, recently updated, what that's really telling us is that we have to have the interactive process. We can't shut down one. We can't say, okay, I'm not going to take any accommodations, and vice versa. We can't say that we're going to have all 100% of our staff have accommodation because we don't want to go through with the mandates, right? So it's going to be a middle ground approach. And so there's a lot of guidance out there. And if you kind of want to see how some previous litigation, you could look at the flu shot litigation as well. Also, as with any employment policy, employers that do have those vaccination requirements may need to respond to allegations of whether or not had a disparate impact. So one thing, this is part of the FAQs, if your portion excludes employees based on race, color, religion, sex, or national origin, employers should keep in mind because some employers in those demographic groups may face barriers to receiving the COVID-19 vaccination. Some employees may be more negatively impacted by the vaccination requirement. So they put that right out there as, could be, in a sense, discriminatory depending on the scenario by forcing those vaccinations. So it's very difficult for employers to put a good handle on it because on one hand, we're seeing the push for those requirements, and then the other hand, we're seeing them update these FAQs to kind of indicate, again, certain demographics may be hindered by this mandate as well. So it's also unlawful to apply a vaccination requirement to an employee that treats them differently based on that disability, race, religion, sex, national origin, unless there's a legitimate non-discriminatory reason. Also, additional to point out, is information of the employee's COVID-19 vaccination confidential? So yes, the ADA requires employers to maintain confidentiality of employee medical information. So although it doesn't prevent you from requiring the employees to provide that documentation, if you're passing that off to managers, if you have a posted list on who's vaccinated, who's not, right? Those all have to be kept confidential. It has to be kept stored and separately from the impersonal files under ADA. So if you have that in with a regular file, take that out and have those separate files. So again, just really important to note because that makes it difficult. We went over the ADA guidance for interviews. If we know it's a requirement, right, we might be able to put it in the job posting, right? There isn't anything that says there, but we know in an interview setting, if we ask their vaccination status, what that can do is require them to divulge information of a reasonable disability or accommodation that could take place, right? So it's all about the rules of engagement, how we can play that without really wasting the employer's time, right? Because if you have a position, I can understand that if you have a position that's going to require this vaccination, you don't necessarily want to waste your time, but we still have to keep in mind this guidance was just recently updated, so we know it's important to note, 10/13/2021, it's definitely been emphasized throughout all the guidelines. Under the ADA, may an employer require COVID-19 vaccination for all employees entering the workplace, even though some of the employees may not get a vaccine because of a disability? Yeah, so yes, provided certain requirements are met, that goes back to ADA hardship, right? Under the ADA, an employer may require an individual with disability to meet those qualification standards if it's job related, consistent with that. If that person with a disability would pose a direct threat to the health or safety if they weren't vaccinated, and they do go further and define a direct threat is a significant risk of substantial harm that cannot be eliminated or reduced by reasonable accommodations. So we can look at, and Jesri is going to probably have a better handle on government affairs. If we look to New York, those exemptions, they wore a mask, which again, we still don't know what those accommodations are going to look for, depending on what agency we're with. We could see if, again, would these qualify? So we'll have to keep an eye out for that. Under ADA, if an employer requires COVID-19 vaccination for employees physically entering the workplace, how should an employee who does not get COVID-19 vaccination because of a disability inform the employer? That employee with a disability who does not get vaccinated for COVID-19 because of the disability has to let the employer know that he or she needs that exemption for requirement. So again, I think that the reason why I think they put that as important is we don't want to make it known or show that we are hey, here's your exemption. Just fill this out, right? We need to do it in the correct way. We need to put out that there is a mandate and then give them the option to fill out those accommodation requirements. And then we on our end do the due diligence to see if that's accommodation that we can actually give. These are all updated. There's full answers on FAQs. For time's sake, I couldn't pull out all of them. And again, this is just the shortened version of them. So they actually go into detail a lot more. So at this time, Jesri, if you want to look at and talk about the government affairs section, I want to allow him to talk about.
Hey, thanks, Rachel. I apologize. I had some computer stuff wrong earlier. So if you called on me and we heard some crickets, a little bit of technical difficulties, having some issues with the computer today. Real briefly, just a couple things, and great work covering so much information, Rachel. And as you may have mentioned on some of it, you know, some of this may change a little bit. The update on my end isn't as much technical in the weeds with the policy and what you can all expect. It's more so from the political side of it in the government. You know, some people are saying, is this really going to happen? Will this be challenged? And so what I'd like to do is just provide you a couple of updates of what we're expecting to happen. And then, you know, and then what might be a likely scenario. So what we're expecting to happen is one of the most recent updates, logistically, just how these processes work, where a becomes a federal rule. It has to go through its governing agency and get approval. Well, we were updated by end of day Monday, as in 2 days ago. OSHA completed its regulatory review process. Once that process is completed, so it just ended Monday, it's at that point is when they release to the public what the new rule and the regulation will be. So we are literally anticipating any day now, any second now, could be while we're still talking, that the final rule will actually be released, so that we will have a concrete update on how all the enforceabilities will be done. You know, if the number for the fine for not able to comply remains the same, all that stuff will be worked out really, really soon. That's what we know is going to happen in the short term. We also know from this standpoint is that there are 22 states currently, 22 states attorneys general who either have or are planning to file, I believe 22 have already filed lawsuit against the federal government, saying that we are not going to implement these policies in our states. I will say, if you're listening from Pennsylvania, Pennsylvania is not one of those members, so we don't anticipate any delay on this end. So what has happened with those states attorneys general pressing, you know, suing ultimately the federal government for this rule implementation? As you may have heard, you professionals in the human resource world, and maybe owners or key members in management, is there's a lot of concern on, hey, what happens when we don't get an employee that doesn't want to apply, has their reasons why they don't get a vaccine. You know, are we going to be hit with these things? Is it going to really hurt my ability to retain and attract new employees? How do we deal with that? That's a lot of unanswered problems. And because of some of that, some of the largest business groups in the country have all piled together and is in the process of pleading with the Biden administration to put a stay on this order so that it doesn't go into effect right away. We don't know what the answer is that, but that's something that could happen. Obvious reasons is, you know, it's not lost on the supply chain issues that's currently affecting the economy. This is just another, what many in the business community see as an unnecessary hindrance to our operations. And at a time right before the Christmas season, when usually a lot of employers hire seasonal help to deal with increased demand, this could further prevent those things from happening. So the ask was, especially if you think about organizations like the trucking associations that logistically pull things across our country from one side to the other, and they're saying, hey, you might have to cut 30% of your workforce due to non-compliance of vaccination status. That's only going to further hinder those things. And so the pitch to the Biden administration is, hey, can we get a stay wait till after the holidays before we start the implementation phase of this? That may be in the realm of possibilities to be determined still. And again, the other side of that is the 22 states who are currently suing the federal government, saying, hey, you're going to cause too much of a disruption in our economic chain right now. People need work. Don't punish those people who are still able to work in a safe manner. There's many employers who are trying their own vaccine implementation rules, regardless of the government telling them they have to. Don't punish those ones who are trying to comply. Work with us, not against us. Because there's that many states suing right now, what could happen, and it's not uncommon, we've seen this in the past, is they could offer, the federal courts could offer a stay. And that stay similarly would put a pause on the regulation where the regulation may not go into effect right away, and they could pause it until the courts could hear this both sides. Likely, the courts will expedite this hearing and it'll happen sooner than later. Now, my legal disclaimer that we put on all this is please default to everything you just heard Rachel say, because especially in the state of Pennsylvania, we fully anticipate Pennsylvania to fall right in line with the Biden administration's rules and implement according to their timeline. These are just some things that we would like you to be aware of that could happen. Lastly, something that just happened as early as today is the Congressional Review Act has been engaged. The Congressional Review Act becomes engaged when a majority of those in Congress, either Senate or House, initiates proceedings to essentially what it does is they overturn a federal regulation. If they have enough support in both houses to support to overturn a federal regulation, at that point they can do that. So that process has been begun. Time will tell if there's enough votes or support to overturn that. No one really knows where that stands right now. However, I believe initially there was 42 senators that joined the initial this morning. They're still they would only need 8 more to officially make this thing go, and that was as early as this morning. So as far as from a government affairs side, those are the things that we're seeing, and those are the kind of things we're expecting to kind of watch out for. And my last parting shot is please default to everything, all the really good information that Rachel just provided you all. And thank you for your attention today.
Yeah, again, thank you so much, Desiree, for adding that the government affairs, and because this is tough for a lot of employers to navigate, because it's not black and white. We know that if I think based on the majority of the people is first find out if you're a covered contractor or subcontractor, because a lot of employers that I talk to really fall themselves in holes. If you're a subcontractor or contractor, you already have additional requirements, and so they mentioned things like banks. Federal banking industries and services. So if you're in part of that industry, remember, if you sell any types of goods or services, reach out to your sales team. Hey, are we considered a government contractor? You already know that you have to do things like AAP. So we know we meet with you guys a lot. So we do a lot of AAP plans for you guys, affirmative action plans. And so we know that most likely if you're doing those kind of things, you do government contracts or a subcontractor. And so when they define subcontractor is if you provide services to a federal contractor, that's the main one, you are considered in that group. So again, yeah, we have to look at states. If you're, we have members in Ohio and New York, you're going to have to kind of keep up with the litigation that's going to happen in those states. Things are going to flip flop. It's going to be hard to navigate, but what we don't want to do is not have you guys prepared. So again, on file, the first thing we should do is start surveying our teams, figure out where we're going to be at, make those forms available. If you guys are a member, you'll see on the member portal that we include all of those forms. We have a form for reasonable accommodations, so religious accommodations, as well as medical exemptions. Start figuring out how you're logistically going to get that and track those exemptions, because we just know based on what's given, we know that we're going to have something on file. So because we want to make sure that we answer you guys, I'm going to stop recording. I do want to mention as well that we do have another webinar coming up put on. So it's going to be COVID-19 facts and myths on November 17th, another free offering for our members. So if you're interested, you can, sign up for one of those. But if you do have additional questions that you don't feel comfortable addressing, please reach out to us. As always, if our email address is hrservices@mbausa.org. Those would go to a team of us consultants, as well as our legal team is on there. But again, thank you for your time. We are now going to stop the recording and open it up for questions. You can go ahead too and unmute yourself. If you have a question, you could look also use the chat feature as well. We know again that there's a lot of people on the call, so that's why we did decide to mute everyone coming in.
Hi, I have a question.
Yes.
Can you hear me okay?
Yes, we can hear you.
Okay, since the COVID vaccine is under emergency use authorization and they're unapproved, unlicensed, and experimental, is it true that no one can be coerced to participate in this under the Nuremberg Code? And that the FDA does require informed consent of the employees for medical research?
Based on the recent litigation that we're seeing right now, that has not been a factor. The only thing that's really coming into play is the exemption for religious or disability related. However, we're seeing some action, and that, and Judge might even be able to speak on this too. In Texas, we know that has become forefront as far as FDA regulations. It's interesting enough when you talk about accommodations for under Title VII. It doesn't have to be a formal sacrament. I don't have to say I'm Catholic and I need a religious exemption because of this. You could also, Scientology is included, any moral belief that's held. So I would say the short answer would probably be generally no, not under that. However, that would simply probably fall under religious accommodation as well. Does that make sense? They're just not
and to follow up with that, if the employee receives an the vaccine and they have an adverse effect to the vaccine, because a lot of people are having some effects, like my neighbor couldn't walk for 2 months. Does their health insurance provide complete coverage, or does this go under workers' comp since the employer's requiring it? And then to follow up with that, if an employee should die from that, would their life insurance policy cover that? Because there have been about 8,000 deaths on the VAERS, or more, I think 16,000 deaths on the VAERS system regarding vaccine adverse reactions. So, I just wanted to know if that's
that's a question that we talked about a lot. We've looked into this a lot too. The short answer is, yeah, it's going to be on your workers' comp. Things have been, because it would, just like you said, it's considered business requirement. So if you require that, that's why they're also mandating paid time off for those vaccinated, because there are those side effects that can last a couple of days. So it's just one of those things that unfortunately would. I kind of expected, but I was incorrect with my anticipation that maybe the Biden administration would take off those. But again, it probably wasn't within his rights to be able to do that. But again, just like any other requirement of the job or getting hurt, unfortunately, those would come. I mean, I could walk in and slip and fall in the parking lot, and that comes on the workers' comp. So it's one of those things. And again, I know that this is tough for every employer. And I just want to say the one thing I want the community, because we are such a great organization in terms of the members. And so I just, big ups to everybody, because this is a very difficult thing for us all to navigate together. And what we don't want to see is everyone kind of divide, right? We're better as a team. But I will say that nobody on one side can have a complete stance, right? So we've seen, those that are fully for, hey, let's get vaccinated, and we're going to require this, and then don't take in accommodations, under Title VII, and then are going further and asking things in interviews that are illegal, right? They're going to have litigation that way, and vice versa. If we take the stance, we're not going to require our employees to do that. That could mean, bottom line, losing money in terms of revenue and being out of compliance, which could result in fines. But I do want to say, I mean, there's a middle ground somewhere. I think when we look at these accommodations, I think if you look at your own populations, That's why the surveying is so important. If you look at, we're kind of split. Most employers that I talk to, they either have about 50-50 or they're saying 30-80, kind of a combination or 80-20, a combination of people who are vaccinated or not. And so we don't want to alienate one group or another, but we do want to ensure that, hey, we're following requirements, but we're also, taking in account for religious and medical accommodations as well. So I see, can we require employees to use PTO for the vaccines, or do we have them give them additional time off? That depends on where you're mandated. So if you're a government contractor and you're required to give, sick pay or things like that, this is going to be tricky. Last year in 2020, by litigation purposes, if we were under the paid sick leave, if you had a reaction to the vaccine or you needed time off, that was included in there. When it becomes optional, there's where the line is blurred of whether or not it's a requirement. So if we have just regular FMLA standards, if we follow, we offer time off but not paid, then we would, yes, dip into those vacation. So if you want to get vaccinated, right, you want that time off, we're going to allow it, but you're going to use your vacation. So that particular answer would depend on, are you in Pittsburgh, for example? If you're in Pittsburgh, there's going to be those requirements. PA, under Governor Tom Wolf, he has his own requirements. So if you fall under those categories, you may not be able to dip into those. So if you need help figuring out for sure, you can reach us to us afterwards and we'll definitely help you figure that out. But it's going to depend exactly if you're mandated to provide pay or not. And if you're mandated under paid sick leave provisions, then you cannot force them to use their vacation, which means it would be an addition. So do we get the question of business necessity? Is the government requiring us to mandate vaccines? They're not really given any guidance on business necessity, what that is. It has to be kind of decided by the employer. Again, we just know on file that we're either going to have an exemption card or form or the copy of the vaccine. If it is required by the mandate, that is essentially the business necessity that we have. So as to answer that question, if you don't have another business necessity as the employer, then your necessity would be the mandate itself. The fines, we won't know what the fines, that isn't until the full guidance is approached. We've heard, and Desiree, you might need to add something, is that it could be $14,000 a day per non-compliance. But we're still waiting for Medicare to release that documentation. That, again, we expect it to be out. And then when OSHA has their guidelines, then they should probably release non-compliance fines for that.
In short, you're right, Rachel. Right now, as it stands, the expected fine, until we hear otherwise, is supposed to be $14,000 per occurrence per person. Unfortunately.
Yeah, so it's important to move fast, especially if you're a federal contractor, or because we've already missed those deadlines, and really the only vaccination that they could take would be Johnson & Johnson. But at minimum, right, we still have to have those exemptions on file. So we'll want to encourage sending that out right away, because we don't know when OSHA is going to fall, and we just know any day. The sooner you get out that. How is the 100 employee calculation made? It's going to be, they note that it's included part-time. So if we look at things like FMLA, if even temps would fall into that category. So it's going to be anyone that essentially is getting paid for services. They've also mentioned contractors, so I believe that would fall 1099. So most likely, another thing that you'll have to think about is joint employers. So if you are an employer that has a HR department that rolls out to 4 different companies under different tax IDs, under FMLA, you are considered one. If you have any shared operations, so if you have a general manager that oversees 2 different divisions or 2 different businesses, you're most likely included. So for that exact answer, if you're unsure if that 100 calculation falls to you, then you want to reach out either to your attorney, or if you're a member, call our hotline. We can help you with that. There's a standard list of questions that asks you whether or not you're considered that many employer, but most likely you're going to use the same standards that you use for FMLA. And that's kind of what we see. How can you ensure HIPAA compliance, right? Compliance as far as confidentiality. when the pandemic went in, not to wear a mask, right? If we have a policy that says unvaccinated employees have to wear a mask and vaccinated employees don't have to wear a mask, then there's a business need why we would need to know that vaccination status. But that doesn't mean we want to broadcast it. So we would, some of the advice we gave is, send an email out and say anyone, who, we're following CDC guidelines, those who are vaccinated don't have to wear a mask, vice versa, right? We know CDC guidelines consistently change, so we have to keep up with the most updated. But if that's the policy we had, then we would have them submit documentation, and maybe their managers, because they're managing them, would know their vaccination status. But let's say, a manager of another team wouldn't be privy to that information. So it's really, as we're not broadcasting any of this information, we're keeping it. And now, obviously, if you have a small employer and people are going to look at it and says, okay, well, people who wear a mask are vaccinated, and people who wear a mask aren't vaccinated, we can assume that, but we as the employer are not broadcasting that information. So even if information can be inferred, it's okay. It's not really something that we can control, but we can ensure that, hey, we're not saying, hey, are you vaccinated at a team meeting, right? Or, hey, here's the requirements. You want to give them, hey, this is the requirements. Here's where you submit the documentation. Let us know if you have any questions. Accommodation requests could be made to this person. And it looks like, Sam, thank you. Looks like you added a link for HIPAA professionals privacy guidance. So that's nice. I'm sure that has a lot of good information as well. Some employers, I'll just note, if you're not a HIPAA employer, these confidentiality requirements still fall to you. So there's that little bit of confusion too. Can we lay off unvaccinated employees until this either gets overturned? Maybe, maybe not. So that's part of the reasonable accommodations. We also depend on if they're going to get unemployment, and some states have come out. I think Iowa was the first one that said, hey, if you get termed for not vaccinated, then you're included. As Jesri kind of pointed out, Pennsylvania is more leading to the Biden administration, so we may not see those provisions happen. But possibly. It's whether or not an accommodation can be made. Most likely, I would say, hold on until you're finished with those accommodation phases. But let's say you have a technician that has to go in a federal hospital and you don't have anyone else, you don't have any work for them until they're vaccinated, then it could be a possibility. But I would, for your specific case, I would reach out to the legal team, again, use the hotline if needed, to really determine whether or not you should in your case, because there's just not enough information to be able to answer that fully. Should we, an employer around 50 employees, worry about this mandate at this time? I think if you have 50, I wouldn't necessarily worry about it in my opinion, because I think we're going to see a lot of litigation that could stop it. I think it's unique that the government contractors had singled out and taken away certain product requirements. So for those manufacturing companies might not be affected as much, so I wouldn't say worry, but I would at least do some surveying. Since you're a PE manufacturer with no federal contractor connections, then most likely this will not fall to you, because in my opinion, litigation might put a stop to it in general, but it's still good to know just in case, because in politics, nothing's guaranteed. Things change on a daily basis, and we want to make sure that you're prepared. So at the minimum, I would suggest doing that survey, making sure that you're getting an idea. If you only have, let's say, 5 people not vaccinated, then the impact for you might not be as bad unless those 5 people are critical to your organization. So if you're your engineering manager or your sales executive that brings in a majority of your business, then you're going to want to watch legislation. And we're also going to keep an eye out for those court cases that are being litigated, because that's going to tell us. But I will say, just because something's in New York doesn't mean it's going to happen in PA. So it really depends whether that litigation's at the federal level or at the state level. We'll also have to look to the guides in our state before we make some decisions as well. I do not see any more questions, but feel free to chime in if you have it. If not, you can certainly sign off. Thank you for coming. We know this was valuable to you guys, and we hope it, at least the information provided, something useful, and you can kind of take this back and go from there.
Thank you, Rachel.
Thank you.
Great job, Rachel. Thanks for everything.
Thank you.
Great way to go.
All I'm saying is is it almost Friday yet? If that litigation would have popped up right before this call, we would have had even a more in-depth conversation, but we'll have to see
Sure.
when see when that comes up. We may even have to schedule a follow-up call with everybody.
The main thing is just qualify. I mean, all you can do is qualify everything at this point, and you guys nailed it.
Rachel, there's some people that asked for the slides as well, just so you know.
Oh yeah, I'm gonna send that out as well as those accommodation documents and template letter to those employees too. So
Okay, great. Thank you. Bye.
Lori, I can make sure that that recording is available.
Thank you. I just have had a lot of interruptions today, so.
Yeah, and it is a ton of information to follow too. That's why the slides are definitely going to be critical to have as well. So I'll make sure I'll get that out. And
All right. Thank you very much.
you're welcome.